Timing has played a big part of Senate Bill 1309. It'll ban abortions after 6 weeks of pregnancy, before most women even realize they're pregnant. Family members can sue the doctor up to 4 years after doing the procedure. Governor Brad Little waited, to the last possible moment to sign it into law. He did it with an hour to spare. And in doing so, he started the clock to when the law actually goes into effect. 30 days from when he signed it, April 22nd, or 17 days from today. Exactly 1 week after he signed it, Planned Parenthood filed a petition asking Idaho Supreme Court to block it, just weeks before it becomes law. So you can understand their urgency, but the Idaho Attorney General's office thinks it's too soon. They want to slow down the judicial process, even change its course. Joe Paris explains the situational crossroads and where it goes from here.
In response to a petition filed by Planned Parenthood seeking to block Idaho's new abortion law, the Idaho Attorney General's office says they need more time after a quick turn of events. Planned Parenthood filed a petition with the Idaho Supreme Court back on March 30th. Part of that filing included a request for an expedited process,
Did you talk
which
to
the
them
court
today?
Granted the next day, March 31st. The reason for the expedited process, Planned Parenthood wants to get the new abortion law blocked before it's supposed to go into effect on April 22nd. But court records show that the Idaho Attorney General's office, who's representing the state of Idaho in this case, is pushing back. They're saying that things are moving too quickly. They write in an April 1st court filing that, quote, through no fault of its own, respondent did not have an opportunity to file its opposition to the petitioner's motion to expedite briefing and argument prior to the granting of this motion. The AG's office point to three major issues that they have with the expedited hearing. To summarize, 1, the complexity of the case warrants more time and rushing through it will compromise careful consideration. 2, the petition by Planned Parenthood includes issues better served by a lower court. And 3, the AG's office believes that there are other avenues that Planned Parenthood could take to get the relief they seek. In an extended explanation, the AG's office reiterates that they believe a lower court should take on the issue because of the nature of the claims and process. They write that instead of the Supreme Court, quote, the district courts are designed to provide for the timely gathering of facts and evidence as well as to hear disputes regarding such, while the Supreme Court is primarily a court of review. In a responding court filing, counsel for Planned Parenthood argues that there is plenty of time for the AG's office to prepare, pointing to the lengthy opinion on the law in question that the AG's office published earlier this year. That opinion did express significant questions about the new abortion law and the legal ramifications it comes with. Planned Parenthood also pushed back, saying the expedited schedule is reasonable given the circumstances. The Supreme Court is the correct venue, they say, because of constitutional questions, and that other reasons to delay given by the AG's office were irrelevant to the facts in their opinion. The filing does say, however, that Planned Parenthood is not opposed to extending the briefing schedule if the Supreme Court blocks the new law, pending a ruling on the new law. Meaning Idaho abortion physicians could continue as is until the Supreme Court rules if the new law is acceptable or not. The most recent filing in the case is from the AG's office, again pushing back on arguments from Planned Parenthood, including the notion that they've had plenty of time to work on the case. The AG's office argues in part that preparing the AG opinion back in February is different work and is totally different circumstances now than it was back then. So it's wait and see on how the Idaho Supreme Court rules on the court schedule. A spokesperson for the AG's office tells KTVB, quote, as of now, the state would need to file its brief by the 14th, unless the court grants that motion to reconsider and sets a later date. The petitioners would then have to file their brief in response to the state's brief no later than 7 days after the state's brief is filed, or arguments could then be set at the discretion of the court.
That's a lot of Joe right there. Anyway, I was going to say timing, or I should say going to the Supreme Court is not an unheard of thing, straight to the Supreme Court.
Right.
The initiatives bill did that. But I'd have to believe because of timing being an issue with this, that it goes into effect April 22nd, that going to a lower court first would only slow things down because if they don't get what they want there, either party, then it would just kind of advance and appeal through that process.
Right. And if you were Planned Parenthood's legal counsel, if you go to a lower court, it really gets the entire situation a lot more complex. Going through a district court is going to take a lot longer than it would be to get an expedited hearing at the Supreme Court. So if you're the AG's office, arguing that this could be taken up at a lower court is both, an argument on its face, but also it could be an idea to buy time. We'll see, though, if the Idaho Supreme Court accepts this or not. They're still deciding on if exactly the expedited schedule will go the way that Planned Parenthood is proposing. We are expecting to get a ruling and some more information from the Supreme Court really in the coming days and weeks. Again, the big day circled on the calendar for pro-choice advocates is April 22nd. That is when the law is supposed to officially go into effect. That's 30 days after Governor Little signed it. So April 22nd is coming up quickly here.
Yes, it is.
It's going to kind of be wait and watch, though, and we'll have to follow the court filings.
All right. Thank you very much, Joe.